Now we'll begin the interview. We like to make it a form of a conversation because we want you to relax, to feel comfortable, so that we can have a conversation that brings out the best of you.
Thank you, my lady.
Yes, so if you could begin by first of all telling us your understanding of who is an ideal judge of the High Court. If you could paint that picture, and within that frame, you tell us how you qualify to be that ideal judge of the High Court. What are your, special qualification, knowledge, achievements that make you suitable for that position?
Thank you.
You have 5 minutes to do that.
Thank you, my lady. I would look at it in terms of a good judge. A good judge is a judge who is competent, a judge who can interpret the law and apply it effectively. That is both substantive and procedural rules, as well as judicial precedents. A good judge is one who can act independently without fear or being influenced by external forces other than the law and the facts that are on record. Also, a good judge is a person with the requisite judicial temperament. I understand the pressures of advocates and litigants face, and one thing I can say, that a good judge is someone who is supposed to be respectful to the litigants, someone who is courteous enough without compromising efficiency of the court. My lady, on the other limb, I have been in this space, the legal fraternity, for a number of years, and I would say that I've navigated through the profession, through litigation, mediation, and most recently corporate governance. My lady, through these experiences, I've garnered the necessary legal competence. I've gained experience in administrative skills and discipline, and most importantly, my lady, judicial temperament required of a judge. Just in a nutshell, I will demonstrate on the areas and places that I've been, that have equipped, that have enabled me to acquire these skills. I've been in the litigation space with a short stint in a private law firm before I joined the state law office as a state counsel too, rose through the ranks to senior state counsel within the civil litigation department, and this is where I learned how to interpret the law and apply it effectively. I learned how to engage with professional colleagues. This is why I learned that also the courtroom is actually one of those spaces that requires administrative skills, so that the judge must be able to manage the trial process with efficiency and in a just manner. My lady, in the year 2015, I was seconded to the Commission on Administrative Justice as a legal officer. And as you're aware, this is an institution with quasi-judicial mandate of checking on matters to do with maladministration in public service. And the functions mirror what is happening at the judiciary. I was called upon to hear matters, particularly on complaints by the public, engage the other side, the respondent, and ensure that I have all the facts with me before I come up with a determination. So given the opportunity, I believe these skills will come in handy during my period that I'll be serving. And lastly, my lady, I'm currently the head of legal services at Kenya Road Board and the corporation secretary. My lady, this role is twofold. First of all, I'm required to be that neutral arbiter in as far as matters of the management of the board is concerned. Two, I'm also called upon to give legal advice in terms of now the Limbom legal services to management and the board. My lady, this role requires a person to be of high moral standing, someone who can stand as a neutral arbiter, someone who can be calm even when things get hot in the bedroom or in the boardroom, my lady. So I would say with this that I'm judge ready. Maybe I can just highlight on some few areas of where I would say that I've contributed effectively in this country. One, I would say that I've contributed to development of the law through legislative reforms. As you can see in my CV, my lady, I've contributed to a number of regulations, particularly the Kenya Roads Board General Rules 2022 and the Kenya Roads Board Fund, which have enabled the country to manage the securitization process of the road maintenance levy. My lady, another key milestone that I would say that I've achieved during this particular period is that of in the year between 2020 and 2022, I was in the mediation subcommittee of LSK. I would say that, and this is the time when the mediation rules were being developed, and we contributed immensely as a team that was representing the LSK, my lady. So with all that, thank you, my lady.
Thank you. Commissioner Mwanza will take you on the other questions.
Thank you, Chief Justice. Council, I want to take you to Article 11 of the Constitution, which provides that the Constitution recognizes culture as the foundation of the nation and as the cumulative civilization of the Kenyan people and that nation. So my first question is, what is your understanding about the place of culture in our country, and how has the Constitution placed it? That's the first question. The second question is as follows, that one of the emotive issues that arise in courts is the issue of barrier disputes. Now, I don't know, but I suppose you must have read this. Any good law student and person who loves the law must know about the case of SM Otieno versus Umira Kagera clan, and how that defined the law on barrier disputes. That the law, that in barrier disputes, the clan also always triumphed the interest of the individual. Now, subsequently, there is another decision by the Court of Appeal about, which is one of my favorite actually. It's a case of Ontweka because it concerned Akisi versus Zipora Masese Ondieki. And this also is a case by the Court of Appeal that now redefined the case of SM Otieno versus Umira Kagera. Now the question is, what in your view has been the place of Article 11 of the Constitution in terms of barrier disputes? And two, how do you say that there was a departure from the first case, SM Otieno? And lastly, I think those are really a lot of questions, so those, I think that's the fourth question. And lastly is, would it have mattered if, for instance, Ontweka was a Muslim? Would it have applied differently? Thank you.
Thank you, Commissioner, for the questions. I'm looking at Article 11 in terms of it defines culture as the foundation of our nation. It comes in different forms, the way we express ourselves, the language, the celebrations, the cultural and traditional celebrations that we engage in, science and literature. I would like to read Article 11 with Article 2 of the Constitution. This article, particularly sub-article 3, that talks of validity of culture. It's an issue that had previously been addressed in the Judicature Act, so that culture has to be consistent with the Constitution and written law, as well as the judge-made law. And I would say that if you read that together with Article 2, culture has to be practiced in conformity with the Constitution. It has to be practiced in conformity with any other written law. So when it comes to barrier disputes, I'm looking at it in terms of a typical barrier dispute. There are three key issues that the court is mostly invited to attend to, particularly issues to do with where the disease is supposed to be buried, who has the right to bury, who, and once you've addressed it, then under which rights, if he's a Christian, he's supposed to be buried in the according to the Christian rite. The customary law might apply in some instances, or the Islamic law. In the case of S.A. Motino, in this case, actually, culture carried the day. That's what I would say. So that one, the immediate family, in as much as they were allowed to see the sending off of the deceased, culture played a very critical role, so that you had to be buried in accordance with the law customary rules, in as much as that he behaved in a manner to suggest that he had embraced modernity. In the Ontweka case, I would say that it's a departure. The court brought in more clarity in as far as burial disputes are concerned. When the widow and the brothers to the deceased had a tussle with regards to where the deceased was to be buried, the matter went all the way to the Supreme Court. Thank you. All the way to the Court of Appeal. And I would say that this is commendable jurisprudence from the judiciary. It has actually ironed out most of the issues. And I would say that the key issues here were the court had addressed itself as to who has the right to bury initially, and the widow, of course, had taken precedent over the brothers. Two, there was the aspect of the wishes of the deceased. And in this case, it was not clear on what the deceased wanted, but I would say that I would infer it from the way he behaved. I happen to be personally known to the deceased person, and if you looked at the home that he had constructed in his rural home in Kisii, it was relatively small and not of his stature. But the home that he had done in his farm in Kamulu befitted the stature of the person that he was in the society. So the way he behaved, it can be inferred with how he conducted himself during his time. Two, on the issue of who to bury, in as much as it was not an issue before the court also addressed it in terms of the legal proximity between a brother and a sister and the spouse, who takes precedence. So the court created that hierarchy where the immediate family, that is the nuclear family, and the children, in the absence of the spouse, would actually have the right to bury the deceased person. Okay.
That's all?
Oh, yes. On the last limb, I would, if Mr. Ontweka was a Muslim, what would have happened? I come from a mixed family, as you've noticed from my name. I'm Catherine Kasim. I know of some little practices under the Islamic law where the eldest male relative is the person who is responsible for matters to do with the burial of the deceased. But I'm looking at it in terms of now myself being a judicial officer, and with the limited knowledge that I have, I would call upon the Qadi to come in as an expert to guide me on matters to do with the burial of a Muslim.
Okay.
Thank you.
Thank you. Just one last issue. I noted something interesting that the court said in that case.
Yes, sir.
And it's important that because you spoke about the qualities of a judge, and the court says that the faction of the law considered humanness as a crucial ingredient in the crucible of justice, and therefore it ought to be factored in the process of judgment making. In your view, what is humanness? What is humanness in judgment making? That will be my last question.
Thank you, Bwana Commissioner. I will attempt it. Humanness in terms of decision making, particularly
Judgment making.
In the judgment making, I would say that first of all, where does the judiciary derive its powers from? I would look at it in terms of the Constitution. Judicial power is derived from the people, and when you talk of the people, you're supposed to look at them as a whole. First of all, you have to treat them with respect, and you have to bear in mind the realities of this human being that you're handling, so that you have to deal with them with respect. You have to deal with them in a courteous manner, and in your decisions, you should actually ensure that the dignity of the human is upheld.
Thank you. Thank you. CJ, that's all from me.
Thank you, Honorable Chair. Ms. Kasim.
Thank you.
I would like us to have a conversation on the difficult subject of guilty but insane. It is often said that persons who have mental challenges do not belong to prison, and we grapple with the issue of whether one is guilty by reason of being insane, or whether one is guilty but insane. So fast forward, you're a judge, you're undertaking a trial. The person who appears before you, the accused person, is said to be insane. How would you proceed with such a matter?
Thank you, my lady. I would look at someone who is insane. This is a person who has impaired mental capacity to stand trial, and not being a medical practitioner, I would first of all ensure that the same is ascertained by a licensed medical practitioner. So I would take the person, first of all, to be examined as to whether they are sane or insane, to ascertain whether they are fit to stand trial. Two, in an instance where an insane person, it has been proved that the person is indeed insane and cannot stand trial, I would make orders to have the person held at the pleasure of the president. Because I'm looking at such a person, they can be a danger to themselves and a danger to the society. That's how I would handle it, my lady.
So what you're saying is that without any trial, you sentenced him to serve at the president's pleasure?
No, my lady, of course I'll carry the trial, I'll do the trial process.
So if a person is mentally challenged,
yes, my lady,
he doesn't have the faculties of his mind are not in order, how do you find such a person guilty so as to sentence him to serve at the president's pleasure?
Thank you, my lady. Once I get the necessary documentation to ascertain the mental capacity of the accused person. I would say that I will conduct a mini trial within a trial to ascertain as to whether he can stand trial, because the mental capacity sometimes varies from person to person. There's some that can actually stand trial. So I would say that I would conduct a mini trial to understand if they understand the trial process in the first place, and that will guide me on what to do next. And in this case, if they do not have the mental capacity to stand trial, then I would direct that they get the necessary medical assistance.
I have never heard of a mini trial. That must be
Trial
something
within
new.
a trial, my lady.
Trial within a trial. I don't want to go to that area.
Thank you.
But supposing the person was insane at the time he committed the offense,